emotional damage. And because the claims of the injured parties within that Ukrainian concept of moral damages are restricted to similar emotional damage, and also those claim amounts fall within the wide bandwidth in those Ukrainian cases. And then, with the application of Ukrainian law, we saw a reasonable ground for increasing the emotional damage claims amounts under Dutch law. And we can imagine that this feels to the relatives as if they're being shortchanged. But the Public Prosecution Service is not just here for the relatives in this case, they're also here for the four accused and for to represent the principle of equality before the law. So we've listened to the relative counsel with our heart and our head, but we see no reason to reconsider our earlier assessment of the scope of the damage to be granted. And the same goes for our earlier assessment of the starting date of the statutory interest. And now we will go into the additional documents that were received after our closing address. In its closing address, the Public Prosecution Service deemed one injured party to have no case, and that claim was to do with the loss of her minor grandson, which the injured party was living with according to that claim. We've explained previously that we felt it wasn't sufficiently clear whether the injured party had the required close relationship with the victim. After our closing address, their counsel submitted additional documents to further substantiate that relationship, and those submitted documents, in our opinion, are sufficient to assume kinship. But with regards to living together as a family, the substantiation, we feel, still falls short. Those new documents show that the injured party lived with the victim regularly and sometimes for longer periods, and that they regularly went on holidays together. The injured party is seen as a second mother, and until the 17th of July 2014, she certainly supported the family that the victim was a part of financially. This information and the information provided earlier about living together is not clear-cut. Is not clear-cut about them living together. And in addition, that period of cohabitation was too short and not continuous enough in order to assume cohabitation legally speaking. So we maintain our position that this particular injured party has no case. After the closing address, other injured parties also submitted additional documents, and because the Public Prosecution Service already felt these injured parties had a case based on their earlier submissions, we have no further remarks on that subject. That brings us to the claims for damages of two relatives that have not been discussed before. Their criminal injuries compensation form was submitted before the closing address and then added to, so they did that in a timely manner, and they're both claiming 40,000 euros in moral damages, and in their explanation of the claims they mention their mental suffering that they suffered because of their loss, and they express this as emotional loss and emotional distress, psychological damage. And then they're also claiming half of the material damage, that is an amount of 3,000 euros in compensation for the loss of a laptop of the victim, and also they're claiming over 12,000 euros in compensation with regards to travel costs to the crash site in Ukraine in July and August 2014. And before we talk about the substance of the claims, first we will look at some legal preliminary questions. First, the circumstance that both parties used one criminal injuries compensation form. The court asked the Public Prosecution Service to look at the requirements of a compensation claim, which is the use of one claim form per injured parties, that these two injured parties have included their claim in one form and then jointly provided an additional explanation to that, we feel is no formal objection. It is clear what the claims regard, and according to these relatives, having to fill out the form separately would be too stressful for them mentally. And with regards to the authority, the jurisdiction of the court, we draw the same conclusion as with regards to the claims of other injured parties. So that jurisdiction, that competence is a given. Then looking at the claims on the merits. The two relatives have sufficiently substantiated that they have the legally required close relationship to the victim, and the psychological distress is more than sufficiently connected to the crashing of flight MH17 and the murder of those on board. So the connection between the moral damages asserted by those two parties and the downing of MH17 is therefore a given, meaning that that requirement has been met, that the moral damage can be designated direct damage within the meaning of Article 51F, paragraph 1. And with regards to the material damages, things are slightly different in part. The costs included under the item travel costs to the crash site in Ukraine in July-August 2014 are costs that the two relatives incurred in the context of paying a last tribute to their loved one and other victims in Ukraine. From their explanation, it is clear that these costs should be designated financial losses within the meaning of Article 696, paragraph 2 of the Dutch Civil Code. Based on this stipulation, any reasonable cost for establishing loss and liability are eligible for compensation. But this item of travel cost cannot be designated as such. Nor does the Public Prosecution Service otherwise see any reasons for allowing this. Based on Article 51F of the Dutch Code of Criminal Proceedings, the costs incurred cannot be designated as direct damage within the meaning of paragraph 1 of that stipulation, and even though the relatives understandably see their visit to the crash site as a private funeral, legally speaking it is not a funeral. The claimed cost therefore cannot be designated as costs of funeral arrangements within the meaning of paragraph 2 of that provision, and that means we conclude that the two injured parties on this particular point of their claims have no cause of action. The laptop of the victim was lost in the crash. Public Prosecution Service assumes that the relatives are the victim's heirs. That means that joinder is possible based on Article 51F, paragraph 2, but as we will explain, this damage is not in fact eligible for compensation in our opinion. Further assessment of the claims is done based on Ukrainian civil law, and if the accused are found guilty under Ukrainian civil law, then we have the following legal elements. It's in the legal act as the guilt of the accused and a sufficient causal link.
Which is why they're liable for the damages. And in principle, there's an entitlement to compensation. The subsequent question is, which damages under Ukrainian law are eligible for compensation? Under Ukrainian law, and I'll first discuss material damages, under Ukrainian law, certain pecuniary damages are eligible as material damages, but the damages to the laptop is not covered by that notion, which is why this claim must be denied, because Ukrainian law does not provide for compensation thereof. As far as moral damage is concerned, the public prosecution's position is in line with what it put forward in the public prosecution's address with regards to the claims of the counsel for the relatives, and that means that the claim damages for pain and suffering under Ukrainian law are eligible for compensation and can be considered to be moral damages as referred to in Article 23, Section 2, under 2, Ukrainian Civil Code, Civil Code, rather. And those entitled to file a claim now. Public prosecution has stated with respect to the relatives represented by counsel that the following amounts in terms of moral damages are eligible for granting. Category 1 and Category 2 is €35,000, and the prosecution requests that that be awarded to each and every one of those relatives, and I'm just going to skip a part and now set off with respect to payments by Malaysia Airlines and Petronas, and there's a procedure pending before the European Court for Human Rights, and public prosecution's position is the same with respect to this claim as the claim concerning the other injured parties, and that means that we reach the conclusion that we persist in our position with respect to the injured parties that advised by Counsel for the Relatives, and the prosecution, after the further explanation, considers one injured party to be inadmissible in its claims. The two injured parties discussed here for the first time today have procedures pending, and their claims can be awarded to 35,000 euros, and the measures have to be imposed also regarding committal. And that would be until the judgment becomes final, and the defendant should be convicted. As far as any other claims or further claims, they should be denied. And in terms of material claims, in part they're inadmissible, and in part their claims should be denied. The next point is seizure. And here we're looking at Mr. Gierken's case in which there's seizure, and your court quite rightly pointed out that a number of seized items have been recorded twice, double recording, and upon your request the prosecution has specified these items. And prior to this hearing, you received the specification, and a copy will be incorporated to our reply now, and we are requesting a decision from your court accordingly with respect to this seizure. And an additional claim concerning the two injured parties and the seizure will be handed over to your court once we wrap up our reply. And that brings us to our demand of sentencing. Public prosecution has explained in its address its demand, and we discussed the nature of the facts, the seriousness of the consequences, and the distribution of roles and personal circumstances of the defendants, and possibly we also try to find links with sentences imposed in other cases in the Netherlands and beyond. And the defense did not address this. Pulatov denies any culpability and apparently saw no reason to put forward any circumstances, should he be convicted, that could mitigate his sentence. The defense did argue, however, that Pulatov was wrongly earmarked as a suspect by the JIT at an international press conference, and that his photo should never have been disclosed. According to the defense, this disclosure of his name and image was in breach of the presumption of innocence, and Pulatov, for that reason, cannot be prosecuted. And we already explained in the first day of our reply why this is not the case. We also mentioned that insofar as Pulatov would have experienced any harm in this respect, this could be considered in the evaluation by the court of the sentence to be imposed. And this is something we will be discussing now. And since this is also an issue in the case of the fellow defendants, what we say will apply to all four cases. And we would like to first and foremost mention that your court is at liberty, in principle, to take into account any harm on the part of the defendant caused by public attention for the case in imposing a sentence, even though such attention even though the prosecution has no fault in such attention, or if there's been no violation of privacy of the defendants in the sense of Article 8 ECHR. The latter two factors, seriousness of the harm and violation of right to privacy, are important to determine the degree of harm and the degree to which that should be taken into account in imposing a sentence, which is why we will discuss whether the disclosure of the name and the photographs of the defendants was compatible with Article 8 ECHR, and after that we will be focusing on the seriousness of the harm that the defendants would have experienced with respect to public attention of the case and what the implications are for the sentence. to be imposed. First of all, whether disclosure of names and images of the defendants is an unjustified violation of their privacy. And if we look at this criminal case, well, that is not the case. The fact that the trial is public serves a significant general interest that is a premise of a democratic rule of law. And this trial is being followed worldwide by relatives and also by the public at large. And in order to realize the principle of public access, it was necessary to make the trial accessible to the relatives and the broader public at large by means of a live stream. And during these proceedings, the criminal trial, the names of the 4 defendants were mentioned, and photos were shown, and videos were shown in which they could be seen. And that is necessary for the investigation carried out by your court at a public hearing. And in view of the interest and also the foreseeability of disclosure of names and images of the defendants during this trial, this cannot constitute an unjustified violation of their privacy. Pulatov has not objected against disclosure of the name and video of Pulatov. On the contrary, the defense contributed to that by showing videos of Pulatov they made themselves here at the hearing. And the defense is only directing its attention to the press conference of the public prosecution on 19 June 2019, which seems rather selective because this press conference was the announcement of this public trial in which a judgment would be handed down with respect to the liability of the 4 defendants for shooting down MH17. And in general, this was a liability that the Security Council of the UN, the relatives, and the public at large worldwide were asking for, which is why this warranted a public announcement of the trial. And at the press conference, it was disclosed which suspects would be prosecuted for which offences and what the date would be that the trial would start. And during the criminal trial, the identity of the suspects would be disclosed in words and most probably also in images. The case file contains several videos showing the defendants in which they made relevant assertions and publications of interviews in which defendants talk about downing of flight MH17. And as I said, several of these images ultimately were shown at the hearing in the context of the investigation carried out by your court. And furthermore, the possibility needed to be considered at this press conference that the defendants at a public trial would like to defend themselves, which is indeed the case for Mr. Pulatov. And since the defendants would stand trial in a public trial, there was no impediment to disclose the identity of the defendants. And second, the relatives and public at large were also entitled to know which persons were to be prosecuted and which persons were not to be prosecuted. And previously, there were several names going round and being mentioned in media of potential suspects such as Girkin, Dubinsky, Besler, Borodai, Checkmark, and persons with the call sign Orion and Delphin. And this was a hearing, an investigation rather, that was followed by the entire world. And a lot of relevant information can only be obtained via public channels. And given the rumors about the names, the relatives and the public at large deserved clarity as to who would and would not be prosecuted. And for the relatives are entitled to complain about the decision to either prosecute one person or not prosecute a certain person. And for the public at large, in this case more than in other criminal cases, the public at large had been affected by these offences. In our public prosecution address, we mentioned the 16 countries that mourned the death of their own nationals, and the images of the crash that sent feelings of horror and indignation across the world, and also the resolution of the United Nations that called for an investigation and accountability. The public at large was upset and merited clarity as to who was to be prosecuted and who not. and there was no actual realistic possibility to inform the relatives and the public at large in a less invasive and far-reaching way. Even if the prosecution would have decided to only inform the relatives and to deprive the public at large of this information, there was no way of doing this in a different way, in a more discreet way. Public prosecution simply didn't dispose of all the addresses of all the relatives entitled to the information. The circle of persons was exceptionally large. First of all, not all relatives entitled to information were known to the authorities of the countries involved. And second, the authorities of the countries concerned were not in a position to provide all the current addresses of the known relatives. And for that reason alone, the legitimate public prosecution had to disclose the most important developments in the investigation and the decision to prosecute. And that way, chances were that all relatives would be informed in accordance with the Dutch law and that they would be able to exercise their rights as victims in a hearing in the criminal proceedings. And third, there were other interests pursuant to the law of criminal procedures to disclose the names and photographs of the defendants. And those are interests of investigation and transfer of prosecution. Public prosecution had not only decided to proceed to their prosecution, but had also proposed to take over the prosecution from Ukraine and had ordered the arrest of the 4 defendants, which is why the defendants were placed on the National Most Wanted list, and arrest warrants were issued via Interpol for them. And in order to enforce these orders, it was of the utmost importance that the defendants be recognized and be found as soon as they crossed the Russian or Ukrainian border. And for that reason, the Dutch police and Interpol published the photos of the wanted defendants on the internet. And for that reason, the photos of the defendants were shown at the press conference on 19 June 2020. Furthermore, the Ukrainian public prosecutor had to disclose the names of the 4 defendants in the context of the transfer of their prosecution that the Netherlands had invited them to do. Prior to the transfer of prosecution, the Ukrainian prosecution had to inform the 4 defendants about the suspicions, so that prior to the transfer, they could exercise their rights by virtue of the criminal procedure in Ukraine. And since the whereabouts of the defendants was unknown, this notification took place by means of a letter of request to the Russian Federation and publication of the notification of suspicion in the Ukrainian official bulletin and the website of SBU. And due to this Ukrainian criminal procedure interest, the names of the defendants were disclosed at the press conference. So in short, there were several grounds and reasons to disclose the names and photographs of these defendants, and this was done in accordance with the applicable rules. And for the clerks, in the footnote, there's a reference to earlier footnotes, but that should say 8, 58, 60, 62. Besides these legal grounds to disclose the information, it was also foreseeable for the defendants that their identity would be disclosed. It was foreseeable when they decided to deploy, in front of the eyes of the world, deploy a heavy missile system in an international airway.
And therefore, the circumstance that that identity was disclosed to the world during the announcements of the course of the proceedings was therefore compatible with Article 8 ECHR. However, the defendants can still have been prejudiced by the media attention for their prosecution. And the next question is whether such prosecution cannot be blamed, although it cannot be blamed on the prosecution and it is compatible with Article 8 HCHR, can provide grounds for imposing a lower sentence. And in order to do that, we need to assess the seriousness of such prejudice. Now, it's obvious that every person that is announced worldwide that he is suspected of shooting down flight MH17 will be addressed for that, and it can be assumed to be inconvenient. However, how serious that inconvenience is still depends on the circumstances of the case. In the Russian Federation or in an area with a Russian sphere of influence or control, the defendants will be bothered less than in other countries because the local dominant story is that they are innocent.
the fact that they have no other choice right now than to stay in Russia or in an area under Russian control is not merely because of the fear of public outcry when they would cross the borders, but by the circumstance that an international arrest warrant was issued against them. If they cross the border, they will be arrested, and that restriction of freedom cannot be considered in favor of the defendants because they have no legally relevant interest in evasion of their arrest. In short, in their own Russian-oriented environment, the defendants will certainly attract public interest, but need not fear public outrage and disapproval. Now, that they only experience limited harm is also demonstrated by their own statements. Pulatov stated, when his counsel asked him how this criminal proceedings affected his day-to-day life, the following. It certainly had a very negative impact on my life. I can no longer work anywhere. I can no longer move about. Everybody calls me and asks me what the role was that I played in this case, why I am accused, and at some time you become fed up with that. In short, he states that it had a very negative impact on his life. He can't work anywhere, I can't move around. Everybody calls me, asks what my role is in this case, why I am accused. And at some time you become fed up with it. And of course people is fed up with people asking why he is accused, but it's quite different from the People's Court that is mentioned by the Defense Counsel. Other remarks by Pulatov himself with regard to the consequences of media attention to his privacy is something that we were unable to find in this case. If we missed something in this case, we would like to hear this from the defense in the rejoinder. And your court can consider it in its deliberation. Dubinsky says in an interview that after the start of the court case, he was already fed up with journalists, both from our side as, let's say, not just on our side as with foreign media. Dubinsky says that literally 2 weeks after the start of the criminal case, his doorbell rang and a journalist asked him for an interview. Next, according to Dubinsky, he then firmly refused this journalist and said to him, "I live in a democratic country, so if I want to give an interview, I will. If I don't want to, I will not." And Dubinsky continues to say that the journalist would have offered him serious money, but that he refused. According to Dubinsky, he would have said to the journalist, "Well, you know, I served in the army for 30 years, more than 30 years. I have a great pension, and I'm fully satisfied with that." This doesn't demonstrate large inconvenience for the defendants, let alone the People's Tribunal or the media storm that the defense counsel has mentioned in the case of Pulatov. Furthermore, all of these defendants sought publicity themselves in their capacity of defendant in this case. After announcing the decision to prosecute on the 19th of July 2019, Dubinsky and Gherkin expressed themselves on various occasions in various media and on-internet platforms about the case, and they have also shown footage of themselves. Video interviews of Gherkin, Dubinsky and Karchenko were published on the internet in which they comment on the criminal investigation or on the criminal proceedings or the JIT investigation. The same applies to Pulatov. After announcing that he would be prosecuted, he commented on his criminal proceedings and the JIT investigation. And furthermore, he allowed his counsel to interview him on video and to play these videos on the hearing and on the live stream. And after the press conference of the JIT, he therefore repeatedly chose to introduce himself to the world as a defendant in this case. Now, when we depart from what the defendants have argued themselves, the harm they experience as a consequence of public announcements and the decision to prosecute, and the transparency and the live stream of these criminal proceedings is limited. Of course, we have to assess that the defendants themselves saw no reason whatsoever to limit such prejudice themselves, because they actively sought publicity, and therefore the harm they experienced by the public attention for their cases is relatively limited. That harm, that personal inconvenience of the defendants as a consequence of public attention to their cases does not outweigh, moreover, the seriousness of the offences of shooting down MH17. and the murder of the 298 occupants. It does not outweigh the deep and irreversible distress of many of the relatives and the large shock that it caused for the local citizen in Ukraine and the rest of the world. That inconvenience suffered by the defendants, as Pulatov puts it, highly negative impact that public attention for these proceedings had on his life, was not just foreseeable, but it decreases in comparison to the seriousness and the consequences of their actions. Now that the defendants have not argued any other circumstances that could provide a reason for a lower sentence, the prosecution maintains its claim to impose a lifelong prison sentence to them. And that brings us to the end of our response to the oral arguments of the defense. And we would like to give the last word for some of the relatives that used their right to address the court and said matters including about the interest of these criminal proceedings, the truth and justice. One of them said, "Finally, taking part in these court procedures of the MH17 criminal court case feels like one of the last acts of love that I can perform for my son and all those other innocent lives lost when MH17 was shut down. It is my sincere hope that this court will find justice for us and our loved ones." Another relative said, "4. When the truth is uncovered, I may be able to leave something behind and move on a bit so that my life becomes slightly more bearable." And the third relative stated it as follows: "After 7 years, you would think missing someone gets easier, but it doesn't. Hidden in the depths of grief sits a fire of hope that will never extinguish. Justice is a painfully long road, one where all you have left to hold on to is hope. And your court's judgment will be an important step on this painfully long road to justice." My colleague will now give you the additional claims. Thank you, Mr. Prosecutor. Following the part seizure, there's one question by the court. For a number of objects that were recorded double and stored in containers, the claim of the prosecution is to return these objects to Malaysia Airlines. And the court has noticed that the aircraft was leased or rented by Malaysia Airlines. And my question is, what does that have? What impact does that have on your claim? The prosecution knows about that and also asked for further information about that. But as far as the prosecution is concerned, Malaysia Airlines is entitled. So we believe that these matters should be returned to Malaysia Airlines. So thank you for clarifying that, says the judge. I would like to ask one question. Your Honor, says the Defense Counsel. There are 4 images that were shown. I believe part of them yesterday. I noticed that these were not included in the notes, and it's not always easy to derive afterwards what conversation was shown or what image was shown. In view of the very brief time we have for our rejoinder, we wondered when we will have that and when we will have the English versions of these documents. We will complete them with the visualizations and we'll provide them as soon as we can. About the English translation, I cannot tell you when it will be ready, but when it is ready, I will indeed provide a copy to you or refer to you where you can find it on the website. So thank you, says the President. So this now brings us to the end of this hearing block, and the court will now suspend until the 8th of June. On Wednesday, the 8th of June, we will continue this hearing. And then the defense will have the floor for rejoinder and will have 3 days to do so.